My name is Martha Koome. I'm a judge in the Court of Appeal. When dealing with the issues of children, they are very dynamic. So there is a lot of challenges because things change every time. Today we are faced with delinquency of children. Just in today's paper, we had children just deciding to go to a bar and drink and take drugs and, have sex. Children who are from 9 years to 17 years. I think these are real challenges that we are facing. And what happens is that all those children are arrested, taken to the police station, and the next day they are offloaded in court. About 200 children. How do you deal with 200 children in a day? How do you get children that early accommodated in a police station, a police cell that is probably meant for 10 people, and suddenly you have 200 children who have to sleep in the cells. So there's a lot of training gaps, beginning with the police who are in contact with the children, especially when they are in conflict with the law. Because they have no business to lock the children in the police cells. They should be able to connect those children immediately with their parents or the guardians and then arrange for them to be brought the next day to be processed in the legal way. If they need to be taken to court, they say, you parent, take your child, sign a board here, let's meet tomorrow in the court. But they are no business to keep the children overnight. This just happened this week, and so many other incidences. So there's a lot of room for capacity building of all the people who are involved in the administration of justice. That is just the police. When you come to the courts, there is also, a lot of training that needs to be done to the magistrates who handle the children. Don't forget that they are handling so many other cases at the same time. And matters of children require to be done, with a lot of care, and also must be done expeditiously because you don't want to hold a child in court so that they miss school or they miss a part of their life because you can't put the clock backwards. The life of a child cannot be held because they are court proceedings. So they must be handled with a lot of expertise. Also because children are very good witnesses in court, but you've got to know how to get out the evidence of the child without scaring them. And a child needs support as they come to court. They can't just walk in court and you expect that they are going to perform the functions that they are supposed to perform in court, either as witnesses or either as children who are in need of care and protection. They have been in conflict with the law. They always need somebody to stand by them, to assure them that this is a process and their life is going to connect. Because at the end of the day, we want these children to emerge even more empowered and be able to carry on with their lives, as if they never came to court. Yes. I think collaboration with the stakeholders who are in the area of child rights movement is one of the best practices that I can talk about. Because there is very little that the court can do on its own, or even the police can do on their own, without the help from the other stakeholders who have stepped in, especially to bridge the gap in the knowledge and information by training the police and also training the judiciary, which is supposed to be work to be done by the government, but realizing that our government is also limited in the number of things they can do, the stakeholders are playing a very, very critical role, especially in training. And not just the judicial officers, the magistrates and the judges, also trying to influence the curriculum for the training of police the law enforcement agents, so that one of the courses that the police take is how to deal with the children matters. The Court User Committee is actually now enshrined under the Judicial Service Act, because the Constitution of Kenya requires that every public office or officer must be accountable to the people you render services to, and the Constitution is replete with terms like accountability, consultation. So if I'm rendering services as a judicial officer, as a court, then I must interact with people who are the partakers of my services. So now it is compulsory under the Judicial Service Act for every court station to have a court user committee. And the court user committee comprises of people who come to court. That is the advocates, the police, the investigators, the provision officers, NGOs working in the human rights area, like the children NGOs and the human rights NGOs. They are part of the court user committee. They meet every once a month, and they discuss, the issues in the administration of justice. How can the court run more efficiently? Why are we having backlog of cases? Why are children cases not moving? Why are we not protecting children, especially from violence? And you realize that there's so much work that needs to be done, especially in the area of children, especially children who are traumatized because of violence from their homes, violence from the people around them, sexual violence, defilement and rape, neglect of children. There are so many cases like that which require not just, capacity building of the people in the administration of justice, but it's like in every household, we need to go there and tell them who is a child and what is expected of you as a parent to protect the child, and what is expected of you as a neighbor, as a relative of the child, who are the, duty bearers as far as, a child is concerned. And you realize under the law we are on duty bearers, but we don't bear the duty.